Hello and welcome to this week's installment of Mayor Brown's video series at the Crossroads, CFTC and DOJ Enforcement. My name is Matt Kluchenek, a partner at Mayor Brown and a member of Mayor Brown's Litigation and Dispute Resolution Group, whose practice focuses on derivatives, securities, and cryptocurrencies. I'm joined today by my partner, Glen Kopp, a former federal prosecutor out of the Southern District of New York, and a member of the firm's white-collar defense practice. As you may know, each week our goal is to bring to you an interesting issue involving both the CFTC and DOJ worlds, and today, this week, we have a particularly good one. Glen?
Thank you, Matt. So we've previously talked about the expansion of the CFTC's enforcement into the world of foreign corruption. Now, along with that appears to be this sort of global reach of CFTC enforcement, something that on the DOJ side we're quite familiar with. But Matt, you've mentioned to me in the past that there may be some limitations on the CFTC's ability to extend itself around the globe. And so what I thought we'd talk about today is that sort of overlap of jurisdictional limitations, both on the CFTC and the DOJ. And so if you could, let's start with a brief primer on the CFTC's jurisdiction.
Sure, thanks, Glen. I think the first thing I would say, as many of us in the industry know, there's been a substantial focus by not only the CFTC, but also the futures exchanges on non-US market participants and transactions. And so again, major focus. And as a baseline, when we think about jurisdiction in the context of the CFTC, we really look at two components. Number one, we look to see whether or not there's a commodity interest involved. And then number two, we look to see whether there's a nexus. When we think about a commodity interest, of course, we're looking to see whether there's a swap, a futures contract, an option contract, a retail commodity transaction, and certain other types of leverage transactions. So if you have a commodity interest, checks the box on one component, and then we go to the more nebulous concept, that of whether or not there's a nexus to the United States in terms of the conduct.
Thanks, Matt. And one of the areas in which this has actually been recently litigated, or a recent case that's quite impactful when it comes to CFTC jurisdiction, is Prime International, a Second Circuit case from a few years ago. Could you give us a bit of some of the factual background of Prime International, and then we'll sort of get into the details and why that's a significant case?
Sure, and as you said, really impactful case in this space. 2019 decision by the Second Circuit is a civil case in which the plaintiffs, a trading firm, traded futures on the New York Mercantile Exchange, one of the exchanges in the U.S., of course, owned by CME Group. And in the action, the allegations were along the lines that the defendants traded physical crude oil, Brent crude oil, in Europe in order to manipulate the Brent crude benchmark with the goal of benefiting their physical trading positions as well as their derivatives trading positions. And so just in the weeds a little bit here, Brent crude benchmark is factored into the price of futures contracts traded on ICE Europe, which is an exchange located outside of the US. But those prices therein are the basis for determining the settlement price of futures contracts traded on NYMEX. And so the plaintiffs allege that the defendants' manipulative trading and activity with respect to physical Brent crude oil in Europe harmed or caused ripple effects with respect to the futures contract traded on NYMEX. Importantly, plaintiffs didn't allege that any of the alleged manipulative conduct or misleading statements or deceptive practices actually occurred in the US. It was all occurring outside of the US and in Europe. And so the plaintiffs brought a private right of action under Section 22 of the Commodity Exchange Act, alleging violations of the CEA's anti-manipulation provisions, 6C1 and 9A2.
Okay, and so Matt, I think why we're interested in this case, even though it was a private case, private right of action case, not involving the CFTC, is ultimately the decision by the Second Circuit, and the Second Circuit dismissed the count or upheld the dismissal of the CEA counts, and the basis there was an analysis that stems from a couple of Supreme Court cases, the Morrison case in 2010, and then the RJR Nabisco case, which relatively speaking, each one of those analyzed the extraterritorial scope of the 10b-5, the securities law, as well as the RICO in RJR Nabisco. And the analysis here in Prime was you have a presumption against the extraterritorial reach of US laws, and that comes from the Supreme Court cases. And so unless there is clear intent by Congress to have the law extend extraterritorially, it's not going to happen. And here the court looked at not only the private right of action, which was sort of the necessary first step, the private right of action provision, as well as the two substantive provisions for whether or not there was a clear indication of Congress's intent for them to apply extraterritorially. And the courts found that there is none. They looked at the text of those statutes and they were lacking in any intent from Congress or indication from Congress that they should apply internationally or to international conduct. And then
Glenn,
yeah,
just a real quick comment here too.
Yeah.
That was really important because the court recognized that certain other provisions like 2I regarding swaps actually included explicitly a statement regarding the extraterritorial effect
that's
or
right.
application of that provision, right?
That's right, Matt. And it sort of shows that Congress knows if they want something to be, if they want a statute to extend extraterritorially, they know how to do that. They know the language to use, and they specifically didn't use it in the anti-fraud provisions and the private right of action provision. But the next step in the analysis that the Supreme Court has set forth for determining whether or not to apply, whether or not the statute applies or can be used here is whether there's a proper domestic application on the facts of the statute. And here in this case, what the court found is that there was no proper domestic application on the facts, because although there was some domestic conduct, meaning the trading on NYMEX that you mentioned, the heart of the statute goes at the defendant's conduct, right? Not the plaintiff's conduct. So it's necessary to have some US connection, but is it sufficient? And it's not sufficient if in fact the defendant's conduct is wholly outside of the US. And here you had, alleged manipulation completely taken care of and done outside of the US on the facts as alleged by the plaintiffs.
And so implications in the US standing alone, where the conduct occurs outside the US, is insufficient, at least in the Second Circuit, right?
That's right. Those ripple effects onto the US market weren't enough. But Matt, is that ruling, Second Circuit ruling, enough to put an end to the CFTC's focus on foreign entities and foreign individuals acting outside the US when it comes to anti-fraud and anti-manipulation enforcement?
Yeah, I mean, that's the million-dollar question, at least from the CFTC perspective. The issue is not over. The CFTC, made clear in its friend of the court brief that from its perspective, it makes no difference if the activity occurred within the US or outside the US, if the implications were with respect to US persons or in connection with US markets. And in fact, if you look at CFTC consent orders, you'll find a large number where it appears at least that all of the conduct occurred outside of the US, yet there was a consent order, without any admission or denial. And so the CFTC has been relatively successful in terms of securing settlements. And I think the other thing to add to this part of the broader equation is, even though you have the Second Circuit with this relatively friendly decision in favor of respondents or defendants, we don't see that in other jurisdictions, including the Seventh Circuit, where many of the exchanges are based, including CME Group or the DC Circuit. So there is some optionality for the CFTC, ostensibly, if they wanted to bring a claim and were concerned about the jurisdictional nexus in the Second Circuit. And really don't see the Second Circuit decision in Prime holding back the CFTC in terms of its efforts in this respect. So, Glenn, in the context of dual enforcement, though, things get really interesting. So now we have the DOJ, it's a parallel investigation, parallel action with the CFTC. And so any thoughts about how, efforts by targets to resist the CFTC jurisdictional play with the DOJ?
So Matt, it's a really good question. I think if we step back for a second and look at whether or not there are actual jurisdictional limits on the DOJ, I think it's an important issue to raise as well, because from DOJ's perspective, whether officially or not, I think they rarely believe that there are limits on their jurisdiction. I know when I was at DOJ at Southern District in New York, I rarely felt that there was a limitation on my ability to bring cases against actors and entities abroad. But there are particular statutes that DOJ relies on that have explicit extraterritorial provisions in them, and the FCPA being one of them. But even there are still limitations on DOJ's ability to enforce criminal laws on overseas actors. And that stems in part or largely from that Morrison case, in which the court recognized that the extraterritorial application of U.S. laws is not the default, and quite it's the opposite. And DOJ had resisted applying that logic to in the criminal context, even in a 10b-5 situation in the Villar case. And the Second Circuit said, no, this default that there's only a domestic application of U.S. statutes also applies in the criminal context. So unless there is explicit language that showing Congress's intent to apply these statutes abroad, you're not going to be able to do that short of some sort of domestic link in the conduct that's alleged. And so you've got, in the securities fraud context with Villar in the Second Circuit, a limitation imposed. Even in the context of wire fraud cases, which is often where DOJ is able to bring in overseas conduct, even there, the focus of the alleged conduct has to show there's no wire fraud extraterritorial application. Rather, you've got to show a domestic link. And the domestic link can't just be, as we talked about before, similarly in the Prime context, that there's an impact on U.S. Victims or on the U.S. market. You've got to actually show that the core conduct that's being legislated or prevented actually happens in the U.S. So in the wire fraud context, what that would mean is the use of U.S. wires, right? You could have a scheme overseas, but if the use of the wires in furtherance of the overseas conduct is U.S. domestic wires, then you've got jurisdiction. And interestingly enough, the Second Circuit has been pretty circumspect and careful in that context. And you have, even in the FCPA context, some limitations on the extraterritorial reach of U.S. criminal statutes. And that's the Hoskins case, a recent case in the Second Circuit, which found that while the FCPA has clear extraterritorial language in it, you still have to work within that language to find any other limitations that there might be for extraterritorial reach. And the Second Circuit found that you could not charge a foreign individual who acted wholly outside the U.S., non-U.S. individual, with conspiracy to violate other provisions of the FCPA or with aiding and abetting liability if that person wasn't an agent, employee, an officer, director of a U.S. issuer or a domestic concern, a U.S. company, and so, or U.S. individual. So there are still limitations being found by the courts for the reach of even, the DOJ's reach, even in the FCPA context. And I think what's interesting there, though, is that was a Second Circuit decision, Hoskins. You had a recent Northern District of Illinois case addressing essentially the same question and finding the opposite, meaning the Northern District of Illinois case said, look, our Seventh Circuit precedent, which is important, as you mentioned, Matt, for CFTC cases, CME cases, our circuit precedent does not follow the logic of the Second Circuit. And therefore, as a district court, I am constrained by that. And the limitation on conspiracy and complicity liability does not exist in the Seventh Circuit the way it does in the Second Circuit. And so there, the court did not agree with the defendants that there was not jurisdiction over them for a conspiracy to violate provisions of the FCPA for non-US actors acting outside of the US. So an interesting potential circuit split that maybe someday the Supreme Court will have to answer when it comes to jurisdiction in the FCPA context.
Thanks, Glenn. And so let's talk a little bit about takeaways. Certainly, I think one takeaway would be that, again, as a baseline, jurisdictional reach of both the CFTC and the CFTC is relatively expansive. But got to draw that clear distinction, between where the conduct is occurring and where the implications are occurring. And depending upon how that falls out is going to inform whether or not you have leverage in terms of a potential jurisdictional challenge.
I think that's right, man. Getting back to, I think the original question you had for me just a few minutes ago is what happens when you have sort of these parallel investigations and you might find that there's a jurisdictional limit, maybe say for the CFTC that you've identified, but maybe not for the DOJ, and how do you handle that? And I think it's very delicate balance for companies and entities to manage and individuals to manage that. I think you have to be clear with both agencies that you find that there might be some limits there. There might be some ability to resist the application of the criminal statute or from the CFTC standpoint. And I think you have to not be afraid to raise that issue. It doesn't mean if you're in a sort of cooperative mode with, say, DOJ, that raising that issue with the CFTC would necessarily blow up your cooperation. I think you have to address those issues gingerly, but forcefully, in the sense that like you have a viable or at least a colorable claim that there's a limit to the jurisdiction over you, and try to manage that. And I think it's doable and something companies and individuals shouldn't give up on during the course of an investigation.
Thanks, Glenn. And just to touch on one final point here, because we get a lot of questions from non-US market participants about this, and that is jurisdictional challenges with respect to futures exchanges. So of course, we've been talking about the civil agency, the CFTC, and the DOJ, the criminal authority, but with exchanges, administratively, it's a completely different analysis. It's one that's largely contractual, and every single futures market in the United States has a rule which says that if you choose to place an order on our market and you choose to contract or transact on our market, then you're deemed to have consented to our rule book, which includes a jurisdictional clause that says that in connection with any investigation or due diligence of the exchange, you agree to submit yourself to that process. And so, so in that sense, it's ostensibly even broader. Just merely partaking with respect to activities on that market is, from the exchange's perspective, sufficient to trigger jurisdiction. So then the question becomes, well, what if I say no, we're not going to submit to jurisdiction? The remedy that the exchanges have would be to terminate your access and not allow you to trade products on their particular market. And if it's a market in which you need to trade a product, because unlike securities markets and the futures markets, there's often only one contract traded on a particular exchange, that can be a really significant implication if your access to the market is terminated. Just want to clarify though, it's different analyses if we're talking about really the DOJ and the CFTC, and then with respect to the futures exchanges. So with that, this concludes this week's installment on CFTC and DOJ enforcement. Thank you very much for watching, and we look forward to seeing you next week. Thanks.